But could the Rwanda plan be less legally troublesome than we thought? One man who thinks so is Professor Richard Ekins, KC. He's from the Policy Exchange think tank and one of the Home Secretary's favourite legal brains, apparently. And we can speak to him now. Good morning to you, Professor.
Good morning.
Now, you've written a paper today on why the government's Rwanda plan might not actually need to get bogged down in the courts after all. I wonder whether, in the simplest terms possible, for those of us with non-legal minds, you could explain how that might be the case.
Sure, it's not quite right. I mean, there is a legal challenge going on to the Rwanda plan through the UK courts, as you know, and that challenge will continue till the Supreme Court rules. But our domestic courts, High Court, Court of Appeal, and Supreme Court, have each said that the Rwanda plan could go ahead while that legal challenge is ongoing. In other words, they've said that they won't grant interim relief to the people who are challenging the plan. Now, what's happened, though, and this happened in June last year, is that a single judge of the Strasbourg Court, the European Court of Human Rights, an anonymous judge, we still don't know who it is, that judge intervened after the Supreme Court had said no interim relief and said we should not remove anyone to Rwanda, the policy should not go ahead until the domestic litigation had run its course. And the focus of my new paper for Policy Exchange today is on whether or not the Strasbourg Court had authority to make that ruling.
Right.
The Strasbourg Court acts as though it can set up a network of duty judges who can intervene at the last minute, effectively overruling decisions of our highest courts on whether interim relief should be granted. And the paper explains, I hope persuasively, that in fact the Strasbourg Court has no authority under the European Convention on Human Rights to act in that way. And our government shouldn't be accepting that it does. It should be protesting vociferously against it. The illegal migration bill that's going through Parliament now does address this practice on the part of the Strasbourg Court. It's a practice that goes on under so-called, it is Rule 39. So this is concerns the Strasbourg Court's Rule 39 measures. So the bill will address this, but of course it remains to be seen whether or not the bill will survive the parliamentary process intact. And
Right.
plenty of members of the House of Lords have said that this is a sort of an outrageous proposition. I think, with respect, that they've misunderstood what it is that the Strasbourg Court is doing, and the fact that really it has very slim legal foundation.
Right. So if the Strasbourg Court doesn't have the authority, then what does that mean today and tomorrow in terms of deporting people to Rwanda?
Well, I think the government could go ahead and send flights. And in fact, I think that's actually the case. And this really isn't the focus of the paper, but I think people should be aware that, in a sense, the Strasbourg Court a month or two ago said that the Rule 39 measures that imposed in June last year had expired. So, in fact, the government, I don't think it's blocked by the Strasbourg Court right now, today. Now, if it goes ahead with plenty of flights, and it's entirely foreseeable that there'll be further applications to the Strasbourg Court for these Rule 39 measures, and the Strasbourg Court may, at the very last moment, when the flight's about to leave, say stop. So I can understand why the government wants a more secure foundation before pressing ahead to avoid the collapse at the last minute.
Yeah, I mean, it's a many-headed problem, the migration, legal and illegal. One of the problems here is the backlog, of course, in processing asylum cases. So Rishi Sunak's promised to abolish this year, standing at more than 150,000 cases. How realistic do you think that is?
Well, it's a tricky question, as you say. We've got a great many cases in the backlog, and to process them all is tricky. The proposal, the government's Rwanda policy and the illegal migration bill, in a sense, are an attempt to cut the Gordian knot by removing people who have clearly arrived unlawfully from a safe state to another country, so that they will not have their asylum claims processed here. They will be removed to a safe state. There's no question of returning them to their persecutors, which would breach the Refugee Convention. So that I think is intended to make not to require a vast amount of processing time here in the UK. There are other practical difficulties, of course, but it avoids that element of the problem.
Okay. Professor Ekins, thank you very much. That's Professor Richard Ekins, KC. He is from the Policy Exchange think tank.
12 minutes.